If there's one topic that quietly costs people the real estate exam, it's contracts. Not because it's hard, because the questions are written to trip you up. They'll give you 4 answers that all sound right, and the difference comes down to one word. So, in the next few minutes, I'm going to make contracts simple. By the end, you'll know what makes a contract valid, the words the exam uses to trick you, and the contracts you'll absolutely be tested on. Grab a pen, let's lock this in. First, the foundation. A contract is just a legally enforceable agreement between 2 or more parties. But for it to actually be valid, the exam wants you to know it needs 5 things. 1, offer and acceptance. One party offers, the other accepts, and they agree on the same terms. You'll hear this called a meeting of the minds. 2, consideration. Something of value gets exchanged. Usually money, but it doesn't have to be. 3, legally competent parties. Everyone signing has to be of legal age and sound mind. 4, consent. The agreement has to be genuine, no fraud, no duress, nobody being forced. And 5, a legal purpose. You can't have a valid contract to do something illegal. And here's the real estate specific one to memorize. To be enforceable, a real estate contract generally has to be in writing. That's the statute of frauds, and it's a favorite on the exam. Now the part that wins or loses points. The exam will ask whether a contract is valid, void, voidable, or unenforceable. These sound similar, they're not. Valid means it meets all the requirements and it's binding. Void means it was never a real contract at all, like an agreement for something illegal. No legal effect, period. Voidable means it is valid, but one party has the right to cancel it. Classic example, a contract signed by a minor, or one where someone was defrauded. The wrong party gets to choose. And unenforceable means it looked valid, but a court won't enforce it, often because it wasn't in writing like the statute of frauds requires. Quick memory hook. Void equals never valid. Voidable equals valid but cancelable. Unenforceable equals valid, but the court won't back it up. Next, 3 pairs the exam uses to trick you. Express versus implied. Express means the terms are spoken or written out. Implied means the agreement is created by people's actions, not words. Bilateral versus unilateral. Bilateral means both parties promise to do something, like a purchase agreement where the buyer promises to buy and the seller promises to sell. Unilateral means only one party is obligated, the other doesn't have to act at all. The classic example is an option, and we'll get to that in a second. And the sneaky one, executed versus executory. Here's the trap. Executed does not just mean signed. An executed contract is one that's been fully performed. Everybody did what they promised. An executory contract still has something left to do. So a purchase agreement you've signed but haven't closed yet, that's executory, not executed. The exam will absolutely test you on that. Now, the actual contracts you'll see on the exam, the listing agreement between the seller and the broker. Know the 3 types: exclusive right to sell, where the broker gets paid no matter who finds the buyer; exclusive agency, where the broker gets paid unless the owner sells it themselves; and open listing, where only the broker who brings the buyer earns the commission. The purchase agreement, also called the sales contract or offer to purchase. This is the big one between buyer and seller. The option, remember, unilateral. The buyer pays for the right to buy within a set time but isn't obligated to go through with it. The seller, though, is locked in if the buyer exercises. The land contract, also called a contract for deed or installment contract. The buyer makes payments over time and gets to use the property, but the seller keeps legal title until it's paid in full. And the lease, the contract between a landlord and tenant. Last, the terms that show up over and over. Earnest money, the good faith deposit the buyer puts down. It's customary, not legally required, and it's held in an escrow or trust account. Contingencies, conditions that have to be met for the deal to move forward. Like financing, inspection, or appraisal, time is of the essence. When you see this, deadlines are strict. Miss one and you've breached. Equitable title, the buyer actually gains this the moment a valid purchase contract is signed before closing. Legal title transfers later. Liquidated damages, an amount agreed to in advance that the seller can keep, often the earnest money if the buyer defaults. An assignment versus novation. Assignment transfers your rights under the contract to someone else. Novation replaces the contract or a party entirely and releases the original party. Different things. The exam will test the difference. That's contracts. And if you remember the 5 elements, the difference between void and voidable, and that executed means fully performed, you've already beaten the questions that trip most people up. If you want the full prep, every topic broken down like this with practice questions, that's exactly what I built Real Estate Mastery University for. The link's in the description, along with a free download of 100 practice questions to test yourself today. Subscribe so you don't miss the rest of this series. We're covering exam math and vocab next. You've got this. I'll see you in the next lesson.